Recent research has shown that stress is one of the most important reasons behind sickness from work, and stress-related absence is increasing. Three-quarters of executives say that stress adversely affects their health. And the Health and Safety Executive have indicated that stress is likely to become the most dangerous risk to business in the early part of the 21st century. So in this month's programme, we'll be looking at the legal duties that employees could use as a basis for a stress claim against their employer, and in particular, the law relating to bullying and harassment. This will include an update on the recent changes to the Sex Discrimination Act concerning harassment. Well, to guide us through the legislation and increasing caseload, we have with us Barrister Ed Williams from Cloisters Chambers, a specialist in employment law. Ed, thanks very much indeed for joining us. How significant is the increase in bullying and harassment cases?
Well, law doesn't operate in a vacuum, Michael, and we have, I think the latest research from the CBI shows that £12 billion are lost in work sick days each year. And 18.9 million sick days are taken a year. So the law reflects that. The law, more and more people are going off sick, businesses are more and more concerned about it, and the law is reflecting that.
And the interest in the press and the media must presumably be having an impact on that as well.
Oh, absolutely. You read the Metro on the tube, or you read the front page of the tabloids as every week or every few weeks as the big banker earning millions or getting millions of pounds in a damages award for bullying and stress. So the public are certainly more aware of it, and through that more aware of their legal rights.
Well, there are three main duties that employees can use as a basis for a stress claim: express or implied terms in the contract of employment, negligence and statute. Now, Ed, interestingly, we say statute, but there's no one statute specifically covering stress in the workplace, is there?
That's right, Michael. There isn't an overarching statute. There are several statutes an employer could choose to use. There's the Health and Safety at Work Act 1974. There's the Protection from Harassment Act, which is 1997. And then you have the equality duties, equality harassment duties in the discrimination statutes. So they're the three sort of main forms of statute any employee would be looking at to bring a claim.
Under existing health and safety legislation, employers have a duty to undertake risk assessments and manage activities to reduce the incidence of stress at work. As part of their overall strategy, the HSE has developed clear guidelines on stress management. The management standard for work-related stress encourages organisations to take preventative measures through a risk assessment. Ed, can you clarify what the powers are that the HSE has really in terms of enforcement?
Well, they've got statutory powers under Section 18 of the Health and Safety at Work Act, but I think everyone's fairly clear in the employment field that they haven't actually used them. So the real development has actually come in common law. And in particular a case of Watson and Morse, where the employee complained that having to work in a smoky environment, his employer hadn't provided him with a reasonably safe place of work, and the court implied a duty into the contract of employment almost identical to that in Section 2.1 of the Health and Safety at Work Act. So in a way the common law has offset the fact that the Health and Safety Executive hasn't made any enforcement provisions, because they probably don't need to now because of the development of the common law.
Which would imply that their enforcement powers haven't really been that effective. I mean, they haven't, I suppose, been needed to be effective.
Well, it could imply both those things. It could imply, yes, that they haven't been necessarily effective, but then the courts have filled a vacuum, as often they do.
So it's the common law that has developed beyond the Health and Safety at Work Act, so as to recognise the contract of employment as engaging the self-esteem and dignity of the individual. The leading authority on the implied term of trust and confidence is the decision of the House of Lords on Malik. Ed, this was a key decision, wasn't it?
Absolutely groundbreaking, Michael. I mean, in effect, the House of Lords implied in law that there is a duty on the employer, not without reasonable and proper cause. They're the important, because obviously if they can behave like that, the law will allow them to, but not without reasonable and proper cause, conduct themselves in a manner calculated or likely to destroy or seriously damage the duty of trust and confidence between them and the employer. So it was groundbreaking stuff.
Well, the trust and confidence term was considered again by the House of Lords in Johnson and Unisys, and here it was extended to the mental health of employees. Lord Stein observed stress-related psychiatric and psychological problems of employees have greatly increased. These considerations are testimony to the need for implied terms in contracts of employment, protecting employees from harsh and unacceptable employment practices. Inevitably, the incidence of psychiatric injury due to excessive stress has increased. The need for protection by employees through their contractual rights, express and implied by law, is markedly greater than in the past. Ed, the obligation then to prevent bullying, is it freestanding, or is it merely an aspect of the trust and confidence term?
Well, it's a good question, because the courts themselves haven't exactly resolved that. So the best advice to any employee thinking of bringing a claim would be to do both, to rely on the freestanding "I've been bullied" and they failed to deal with that, and also to say this conduct amounts to a breach of the duty of trust and confidence, because the advantage of the trust and confidence breach is that it allows a series of small incidents which, although on their own might not amount to a duty of trust and confidence, if you look at them together they do, and the last in the series of those acts doesn't actually need to be a breach of contract. It's a case of Lewis and Motorworld.
Well, the case of Cantor Fitzgerald International is a good example of bullying conduct which breached the trust and confidence term. In that case, the employee contended that his manager had demonstrated his contempt for a presentation by shouting and swearing at him in front of a colleague, frequently calling him at inappropriate times, swearing and complaining about work issues. And the last straw came when his manager rang him during lunch and complained and rebuked him because he'd missed out a set of brackets in a document. Now, Ed, I mean, many in the city might say this treatment is kind of all part of the territory, really.
Absolutely, they would, but just because you're being paid a lot of money doesn't divorce you from your obligations under employment law, and that's certainly Mr. Justice Newman, who was the judge in the case. It was tried to argue to him, well, that's what you paid your money to do, you paid to put up with this, and he gave that very short shrift, saying it doesn't matter who you are, you're entitled to the protection of the law.
The test as to whether there's been a breach of trust and confidence, is that a subjective one or actually an objective one?
It's actually an objective one, Michael, so it's the reasonable person looking at the conduct complained of and determining whether it actually is, whether it does amount to bullying.
Is that harsh on the employee?
Well, it can be, given that bullying is a very personal thing, and what might appear to be trivial matters to us could really affect someone quite substantially. But ultimately, the objective test is the one that's applied, and so the courts are well placed to recognise the difference between minor irritations and upsets that all of us in our day-to-day life have to go through, and those which are basically unacceptable and oppressive.
Whilst general damages can't be awarded for frustration, mental distress or injured feelings arising from an employer's breach of the implied terms of trust and confidence, damages are recoverable where the breach results in recognised psychiatric illness. Ed, how difficult is it for an employee to build a case for psychiatric illness?
Well, it is difficult because it relates, well, there's a case, the key case of Gugai, which established this. And if the breach could lead to foreseeable harm, then, and that harm is a recognisable psychiatric injury, then you can get your damages for that. But the key word is foreseeable.
Can an employee bring a case of negligence in those circumstances?
Yes, the House of Lords in a case of Waters have recognised that you can bring under either negligence or under breach of the implied term, and the employer has to take reasonable steps to prevent foreseeable injury. That's all they've got to do.
But foreseeability, that's a key issue in this.
Absolutely. You could have an employee that it's all bubbling under the surface, their depression, and they've been depressed for 6 months, but it's not obvious to the employer. So unless it's obvious to the employer, unless it's foreseeable to the employer, then that's a defence for the employer. It might seem unfair and a bit harsh on the individual, but that's where the law is at.
To what extent is an employer vicariously liable for bullying carried out by colleagues?
Well, the law recognises that for some acts they might not be, but the critical test is, was the act so closely connected with them carrying out the course of their employment? Now, there's this well-known case of Lister and Hesley Hall where you had a warden of a care home who abused young children whilst at that care home, and the care home argued, well, no, that had nothing to do with his employment. But the House of Lords disagreed because it was his acts of, although he was abusing these kids, they were carried out whilst he was looking after them, so they were so closely connected with his employment. So the close connection test is the key to determining vicarious liability under the common law.
Well, let's turn now to the Protection from Harassment Act 1997 and recent changes to the Sex Discrimination Act. Now, Section 1 of the 1997 Act provides that a person must not pursue a course of conduct which amounts to harassment of another and which he knows or ought to know amounts to harassment of the other. For the purposes of this section, the person whose course of conduct is in question ought to know that it amounts to harassment of another if a reasonable person in possession of the same information would think that the course of conduct amounted to harassment of the other. Ed, to what extent, really, is the 1997 Act used against employers in cases of bullying and harassment?
Well, there was a seminal case a couple of years ago in the House of Lords, Morovsky, which was the first of its type establishing what the duties are. Now, in theory, you can get damages for the type of anxiety and low-level upset that you wouldn't get under the common law because you need a recognisable psychiatric injury. However, recent authorities, in particular the case of Con, have held that the conduct complained of, the harassment, has to be almost akin to a criminal act. So it's a much higher test than perhaps people envisaged a couple of years ago.
And what about the vicarious liability point we talked about a moment ago?
Yes, the House of Lords, this was one of the key things that was decided. The employers tried to argue that they didn't impose vicarious liability. They shouldn't be liable for the individual acts, where the House of Lords said no, Section 3 of the Act actually does impose vicarious liability. So that was the end of that, given that it's the House of Lords.
Well, finally, we turn to the recent amendments to the 1975 Sex Discrimination Act. And these have been introduced to implement properly the EC Equal Treatment Directive. Ed, briefly, can you update us on the changes? What's really happened?
Well, absolutely. What didn't happen with the original provisions of the Act in terms of implementing the directive was it didn't provide for protection from employees against customers where the employer knew or ought to have known and that harm was going to be suffered and could have taken steps to reduce it. So that's now in. And most importantly of all, the definition of harassment had to be on the grounds of someone's sex beforehand. Now it doesn't. It just has to be related to sex or connected to sex. So it's a much lower threshold. It doesn't need to be on the ground of, say, a woman's sex.
Well, with cases on the increase, we will no doubt be returning to these issues again. For now, however, I'd like to thank our guest, Ed Williams, from Cloisters Chambers, for an excellent overview of the evolving law in this area. For now, from all of us here, goodbye.